Hi, everyone. Thank you so much for coming tonight. Tonight, we are going to be continuing working with the seller, and tonight we will be focusing on the residential listing contract exclusive right to sell. You'll notice that it says /rent because this is the same form that you'll use if you have a landlord that is wanting to rent their house out, and you are going to be facilitating that for them. Okay, so what we're going to do tonight, like we do when we review any addendum or form, is we are going to read it line by line. I know that that can be repetitive and you could be like, why are we doing this? But I can tell you from experience that every time I read an addendum or a form, I learn something new. Maybe I interpret it a different way. So let's get started. Line 1, the owner seller. This is the name that is on the tax records. If you don't know what the tax records are, they're the Monsoon in the Flex MLS. There is a hyperlink in there, or a tab, I should say, that will take you straight to the tax records. And that is the name that you put on here. If it's in the name of a trust, you put the trust on there. Whatever is showing on the tax records goes there. Broker is going to be ProSmart Realty. Line 4 is going to be your name. And if you're part of a team or a team lead, then their name goes here. Property, section 2. The owner agrees to sell or rent the real property and all improvements, fixtures, and appurtenances therein or incidental thereto, plus the personal property described herein, collectively the premises. The premises address, if it did not auto-populate, you'll type that. Same with the assessor's number, city, county, Arizona zip code, and legal description. If the assessor's number and the legal description did not auto-populate when you started or created the file and transaction desk, then you can find that information in the tax records or the Monsoon. Section 3, listing and price terms. The agreement, the residential listing contract, exclusive right to sell or rent, is the agreement between the owner and the listing broker. In consideration of the listing broker's agreement to find a ready, willing, and able buyer or tenant, owner gives the listing broker the exclusive and irrevocable right to sell the premises described above. Now, you can use the same form if you're going to do it for rent and sell, but we do like to just do one for the sale and one for the rent, just to make it nice and clear which is which. So if you're gonna have it for sale and for rent in the MLS at the same time, just do 2 different forms. The owner acknowledges that signing more than one exclusive right to sell or rent or other form of listing contract for the same term could expose the owner to liability for additional compensation. The price. The listing price shall be for sale X amount and for rent X amount per month. Plus, in the case of a rental, all applicable lease or rental transaction privilege taxes or such other price and terms as are accepted by the owner. I do want to make a quick note though, as of January 1st, the landlord can no longer accept tax on a rental. The term, this agreement shall commence on and shall expire at 11:59 Mountain Standard Time on whatever the expiration date is. Every contract has to have a clear start and a clear end date. Upon full execution of a contract for sale or lease of the premises, all rights and obligations of this agreement will automatically extend through the date of the actual closing of the sale or lease agreement. Capacity. Owner or any party that owner designates to act on their behalf warrants that they have the legal capacity, full power, and authority to enter into this agreement, deliver marketable title to the premises, and consummate the transaction contemplated hereby. Modification. This agreement may be modified only in writing signed by the owner and the listing broker. Equal housing opportunity. Listing broker and owner shall comply with all federal, state, and local housing laws and regulations, local fair housing laws and regulations, including but not limited to non-discrimination based on race, color, religion, sex, handicap, familial status, national origin, sexual orientation, or gender identity. Every page, the owners will have to initial. Okay, compensation, the fun stuff, but very important. This is how you get paid as the listing agent. The listing broker compensation is not set by law nor by any board association of realtors, multiple listing service, or in any manner other than as fully negotiated between listing broker and owner in this agreement. Should the owner choose to offer compensation to a buyer broker or tenant broker, the offered amount is also fully negotiable and agreed upon after discussion with the listing broker. The owner initials here. That is a very important line. Do not miss that. All funds are to be in U.S. currency. The owner agrees to compensate the listing broker and other broker, if any, as follows. Check if applicable. Retainer. Owner agrees to pay listing broker a non-refundable retainer fee in the amount of X amount within 5 days or X amount of days, if not per the contract, which is 5 days of execution of this agreement, which is earned when paid for initial consultation, research, and other services. This fee shall or shall not be credited against the listing broker compensation. Now, I do want to note here, you have to confirm with your broker if they will even allow a retainer fee. And please note that this is a fee that goes to the broker. It does not go to you. So, very important to know. If you don't know or haven't had that conversation with a broker when you go meet with the seller, just leave it blank. Don't collect a retainer fee. Listing broker compensation. If listing broker produces a ready, willing, and able broker or tenant in accordance with this agreement, or if a sale or rental of the property is made by owner or through any other broker or otherwise during the term of this agreement, the owner shall pay listing broker compensation of sale, 3% of the purchase price. Notice this uppercase, bold, or a dollar amount. This is not the sale price of the home. If you put that, then you're saying that the seller, upon execution of finding a buyer, owes you, say the purchase price was $350,000, $350,000. So it's either 3% or 10,000 or 5,000 or whatever amount of commission you're asking for. Additional listing broker compensation. So these are the options for you, the listing broker. You can ask for compensation if there's an unrepresented buyer. If this is checked, that the owner agrees to pay listing broker an additional compensation of, I put 1% of the full purchase price or X amount of dollars if the buyer of the premises is not represented by a buyer broker. The buyer broker, the owner does or does not authorize the listing broker to communicate owner willingness to potentially compensate a prospective buyer broker depending on the terms of the purchase offer. Requests for compensation should be set forth in the prospective buyer's offer to purchase the premises. You will notice that this has been changed recently. The buyer broker compensation is not set with the seller at this time. The only thing that is set at this time, and what I mean by this time is at the listing meeting where you go to have all the paperwork signed by the seller. The only thing that is set up at this time is, do you or do you not have the authority to tell the buyer broker that brings you a buyer that the buyer or that the seller is willing to compensate them if they bring them a buyer? No matter what, the buyer's agent has to submit with their offer the seller compensation addendum with their offer if they are asking the seller to pay for compensation. So all it's saying is, are they willing or are they willing or are they not willing? That's it. Owner acknowledges that the buyer broker represents the interest of the buyer and not the interest of the owner in a transaction unless the agent of the listing broker represent both the buyer and the owner under limited representation as described in Section 6. Owner also acknowledges that the buyer broker may credit part or all of their compensation to the buyer. If it is a agreement for a rental, then you would put a percentage here, and it's the gross rental amount as calculated for the entire term of the lease. So if it's, say, 1% of a 12-month lease and the rent is $1,000 a month, you get 1% of $12,000. Hope that makes sense. Or X amount upon execution of a lease agreement. Additional listing broker compensation, very similar to up above. If there's an unrepresented tenant, does the owner agree to pay the listing broker additional compensation of X amount or X amount of money or percentage or money if the tenant of the premises is not represented by the tenant broker? Again, do we have the authority to communicate the owner's willingness to potentially compensate the prospective tenant broker depending on the terms of the lease offer? Request for compensation should be set forth in the prospective tenant's offer to lease the premises. Again, with the SCA, the buyer broker will submit it with their offer or their intent to rent, I guess. I don't know if there's so much of an offer put in on a rental, but anyways, I digress. Owner acknowledges that tenant broker represents the interest of the tenant and not the interest of the owner in the transaction unless the agents of listing broker represent both the owner and the tenant under the limited representation as described in Section 6. Owner also authorizes the tenant broker may credit part or all of their compensation to the tenant. If you're wondering what limited representation is, that is dual agency. That is where you represent both the buyer and the seller. Rental, renewal, or extension. This only applies if it's a rental agreement or you are listing a home for a landlord. Regardless of whether this agreement has expired, owner agrees to pay listing broker compensation of X% of the gross rental amount or X amount within 5 days of a rental renewal or extension. Purchase by tenant. If during the terms of any rental premises, including any renewals or holdovers, or within days after the rental's termination, any tenant or his heirs, executors, or assigns shall buy the premises from owner, the sale compensation described in Section 4 shall be deemed earned by and payable to listing broker. Broker dispute. In the event a dispute arises between listing broker and any other brokers regarding payment of compensation, seller shall not revoke or seek to amend compensation previously offered. Any compensation dispute between brokers shall be resolved after the close of escrow in accordance with the realtor's dispute resolution system and as otherwise agreed. Withdrawn canceled listings. The same amount of sale or rental compensation shall be due and payable to listing broker if, without the consent of the listing broker, the premises is withdrawn from this agreement, otherwise withdrawn from sale or rental, or is rented, transferred, or conveyed by owner through any other broker or otherwise. Payment from escrow or rent. Owner instructs the escrow company, if any, to pay all such compensation to listing broker by check, wire transfer, or certified funds as a condition of closing or upon cancellation of the escrow, and irrevocably assigns the listing broker, to the extent necessary, money payable to owner at the closing or cancellation of escrow. Listing broker is authorized to deduct compensation owed to listing broker from any rent or other monies received by listing broker on owner's behalf. After the expiration of this agreement, the same compensation as appropriate shall be payable if a sale or rental is made by owner to any person to whom the premises has been shown or with whom owner or any other broker has negotiated concerning the premises during the term of this agreement within X amount of days after the expiration of this agreement, unless the premises has been listed on an exclusive basis with another broker during the pendency, including the closing of any purchase contract or escrow relating to the premises that was executed or opened during the term of the agreement, or as contemplated by Section 4. It's up to you if you want to put in an after expiration. It would just be really hard to prove that you were the reason why they purchased a home, I guess. So most just leave it blank, but again, it's up to you. Failure to complete. If completion of a sale or rental is prevented by default of the owner or with the consent of owner, the entire sale or rental compensation as appropriate shall be paid to listing broker by owner. If any earnest deposit is forfeited for any other reason, the owner shall pay a brokerage fee equal to the lesser of the 1/2 of the earnest deposit or the full amount of the compensation. Construction. To the maximum extent permitted by law, this agreement shall be construed as limiting applicable provisions of law relating to when compensation is earned or payable. In the event of any express disagreement between any provision of this agreement and the requirements applicable law, the applicable provision of this agreement shall be deemed as modified to the minimum extent necessary to ensure compliance with applicable law. So when we're working with sellers, a lot of them ask, what can I take and what do I have to leave? This is the section of the contract I would recommend they read in detail themselves, just so that they are aware. So fixtures and personal property. For the purpose of this agreement, fixtures shall remain should mean property attached / affixed to the premises. Owner agrees that all existing fixtures on the premises, personal property specified herein, and means to operate fixtures and property, i.e. remote controls like a fan, shall convey in the sale or rental, including the following. I'm not going to read through all of that, but I do want to mention a couple things that stand out. Smart home devices, like a Ring doorbell, a TV mount, not the TV, but the actual mount to the TV on the wall, that stays. Now, if they don't want these items to convey with the sale, the best advice I can give is to have it removed prior to going live on the market before photos are taken. Because if they're there and you don't put it in the contract that they don't convey, then they convey. Another thing is a storage shed in the backyard. Those big Tupperware ones, clients think that they can just take them. Well, they can't. That does convey with the sale. So just make sure that if there's items that the seller is for sure taking, they either remove it prior or you list it in the executed contract and both buyer and seller have agreed and signed that those items do not convey. If owned by seller, the following items also are included, in the sale. Solar panels, an in-ground pool, spa, tub equipment and covers, including any mechanical or cleaning systems, security or fire systems or alarms, water purification systems, water softeners. You'd be surprised how many sellers take their purification and water softeners. Again, if they're going to take it with them, best advice is to have it removed prior to going live. Personal property that is going to convey refrigerator, washer, dryer, above ground spa. If they are going to be leaving these items, it needs to be checked. And you can even go into a description, serial number, whatever you want to do, or you can just check these. If they are not going to convey with the sale, then you need to leave them blank. And you need to make sure that they are not in the listing description. And if a seller, let's say, signs a buyer, accepts a buyer's contract and it has these items on the contract, then they just agreed to have the buyer keep them. So you need to be reading through the contract, especially if they don't want these items to go with the sale, to make sure that you don't accidentally say, yes, it stays with the home. If you have a furnished house, say in a 55 and older, or maybe up north in a vacation home, this is not where you put that furnishings convey with the sale of the home. You would do all of that on a separate bill of sale. It does not go in here. So just keep that in mind and let me know if you have any questions, if that does come up in one of your dealings or one of your with your clients. Leased or not owned items. The following items are leased and not owned by the owner: solar system, alarm system, propane tank, water softener. Other leased or lien items not included in the sale or rental, you can put that here. Please note that if any of these are checked and the owner or the seller has items that they lease, they have to ask the buyer, depending on what it is, if they want it. For example, if it's a solar system, they don't really have the option. The buyer has to actually qualify to take over the lease agreement that the current seller has with that company. And that's a whole different conversation for another day. If it's an alarm system, most alarm systems, if they're leased, it's more like a monthly fee that they have to pay, and they can usually end it with proper notice, but not always. So you definitely want to make sure that if any of these items can't just be ended, and maybe there's a buyout fee, whatever it is, that you have a copy of the contract to upload with your listing for the buyer to review prior to putting in their offer, because that might determine if they actually want to offer on that house or not. Fixtures not included in the sale or rental. Depending on how many items there are, you can list that here. For example, the chandelier in the entryway does not convey. The TV mounts for the TVs do not convey. The above ground spa does not convey. Whatever it might be, you could put that here. If you need additional room, you can put a little note that says see attached document. And then you could have a PDF of all of the items that don't convey, and you can put that with this or with your listing. Agency, owner representation. Listing broker shall represent owner in any resulting transaction during the term of this agreement, except as specified in Section 4. Unless otherwise agreed, listing broker acts as owner's agent only and has the duties of loyalty, obedience, disclosure, confidentiality, and accounting fiduciary duties, as well as other duties imposed by the Arizona Department of Real Estate. Owner acknowledges that listing broker may show prospective buyers the premises and shall not constitute a conflict of interest. Conduct of brokers. Regardless of whom they represent, all brokers have the obligation to treat all parties to a transaction fairly. Disclose in writing all facts known to the licensee that may materially or adversely affect the consideration to be paid for the premises, and disclose that owners or buyers may be unable to perform. Realtors are further obligated by the National Association of Realtors Code of Ethics to treat all parties honestly. Limited representation. A limited agency may occur when listing broker procures a buyer for the premises. In this situation, the same real estate company may represent the owner's interest and the buyer's interest, but not to the detriment of the other party. Listing broker can legally represent both parties with the knowledge and prior written consent of both parties. What the listing broker cannot disclose to clients under limited representation. Confidential information that the listing broker may know about the client without the client's express consent. The price or terms the owner will take other than the price without permission from the owner. The price of terms or terms that the buyers are willing to pay without permission of the buyers. A recommended or suggested price or terms the buyer should offer. A recommended or suggested price or terms the owner should counter with or accept. Basically, there's no negotiation. You can't tell them anything. and vice versa. Well, they can tell you what they want to do and then you just do it. You can't like say, well, I think you could do this. Competing owners. Owner understands that the listing broker may have or obtain listings on other properties and that potential buyers may consider, make offers on, or purchase through listing broker. Property the same as or similar to owner's premises. Owner consents to listing broker representation of owners and buyers of other properties before, during, and upon expiration of this agreement. Listing broker role. Listing broker is not responsible for the custody or condition of the premises and its management, except under separate contract, upkeep, and repair. It is the seller's responsibility to keep the property maintained. Advertising. Owner agrees not to advertise or market the premises in any manner without prior written permission of broker. Multiple listing service. The listing broker is authorized to provide any and all information regarding the premises to any MLS of which the listing broker is a participant and to publish the whatever that word is, such information in print or electric form to MLS participants and general public, including dissemination of the information through internal data exchanges and virtual office websites. Listing broker is authorized to report the sale or rental of the premises and its price, terms, and financing, or dissemination, whatever that word is, through the MLS to MLS participants and the general public. All terms of the transaction, including sale price and financing, if applicable, will be provided to the MLS and may be provided to the MLS even if the premises is not listed in the MLS. Signs. A listing broker is or is not allowed to place listing broker's for sale sign or for rent sign in the conjunction with any customary sign writers on the premises, and in the event of a sale, sold, or pending sign or lease or rented sign at listing broker's discretion on the premises. Seller acknowledges that any public marketing of the premises will require submission to the MLS within 1 business day. Photo videos. The owner does or does not authorize the listing broker to place photos, video images, virtual tours of the premises on the internet and other media, electronic or online media platforms. If authorized by owner to do so, such marketing will be performed at the sole discretion of the listing broker. The owner is cautioned to protect items in view. For example, if they do not want pictures of their children on the web, they need to remove those photos before photos are taken by a photographer. Once they are listed on the MLS, it is forever out there on the web. So use your discretion and advise your clients appropriately. Lockbox key safe. The listing broker is or is not authorized to install a lockbox/key safe. A lockbox key safe is designed to hold a key to the premises to permit access of the premises by a listing broker, cooperating brokers, MLS participants, their authorized licensee and representative, authorized inspectors, and prospective buyers. Listing broker, cooperating brokers, MLS, and association/boards of realtors are not insurers against injury, theft, loss, vandalism, or damage attributed to the use of the lockbox/key safe. If the premises is rented, owner must comply with providing proper notice to tenants pursuant to the Arizona law, which is 48 hours of intent to enter. So if the home has a tenant right in the description of the property on the MLS, you know that you need to give at least a 48-hour notice of intent to enter. Going to the theft, loss, vandalism, things like that, you need to advise your clients that if they have any valuables, they need to remove them or put them in a safe. If there's any guns, ammo, narcotics, I already said jewelry, cash, collectible items like heirlooms, maybe a Babe Ruth baseball sign, whatever, they should not keep those in the house because again, there are bad people in the world and we can't, and while, like for us, like we would never, but you never know. Maybe you accidentally take the key and then you drop it and somebody sees it and they break into the house. Well, you were the last person that accessed that house. So just know that you, number one, should never be in possession of a key. It is not your property. You don't own the house. Your clients don't own the house. And then also, up until you record on a home, your buyer is never to have access to a house. They cannot put their personal belongings there. They cannot be in the house without you present. Because number one, what if they get hurt? Like that's on the seller. That's not on the buyer. So you just have to make sure that you never give access to the house without you being present. And just make sure that you keep the key in the key box where it should be up until the time you record. Offers. Listing broker is or is not authorized to disclose the existence of offers, which includes the sale price, the terms of a sale or rent price, and terms of lease on the premises. Subsequent purchase of lease offers. Listing broker acknowledges that owner has the right to accept subsequent offers until the close of escrow in the case of a sale or until occupancy by a tenant in the case of a rental. Owner understands that any subsequent offers accepted by owner must be backup offers, namely contingent on the cancellation or other nullification of any contracts arising from the acceptance of earlier offers. And if applicable, do they want to accept backup offers? Do they want to withhold verbal offers? And do they want to withhold all offers once owner accepts a purchase contract or lease agreement in the premises? Now, let's go through these three options. Accepting a backup offer, 100%. That means that if offer one in position one cancels and you have an official backup offer, then offer position two goes into position one automatically. You don't have to go back on the market. Withholding verbal offers, 100%. The reason being is because nothing is valid unless it's in writing. So while you can talk to your clients about a verbal offer, you never want to accept a verbal offer until it's in writing. So just, that's what it means. Like you by law have to present any and all offers. But this just means that it's not valid. Get it in writing. Withholding all other, so withhold all offers. That only applies once the client, the seller, is under contract. And the reason why they may want to choose that is because they don't want to be given a better offer later and then sabotage the offer that they're under contract with. And by withholding them, you're not giving them even the thought of not moving forward with offer one. So some people like that as just extra protection. Listing broker will change or maintain the current MLS listing status in accordance with the MLS rules and regulations and any associated policies. Cancellation. Listing broker reserves the right to cancel this agreement unilaterally for cause, which shall include, but is not limited to, listing broker's good faith belief and that any service requested of listing broker or any action undertaken by anyone other than the listing broker is or could be determined to be in violation of any applicable law. The owner obligation. Owner shall provide access to the premises at reasonable times and upon reasonable notice to allow for showing of the premises to prospective buyers and cooperating brokers. Security insurance showings, auto and video. Broker is not responsible for loss or damage to personal or real property or person, whether attributed to use of the key safe lockbox, a showing of the premises, or otherwise third party, including but not limited to appraisers, inspectors, brokers, and prospective buyers, may have access to and take videos or photographs of the interior of the premises. Owner agrees to take reasonable precautions to safeguard and protect valuables that might be accessible during showings of the premises, obtain insurance to protect against these risks. Broker does not maintain insurance for the owner's benefit. Persons visiting the premises may not be aware that they could be recorded by audio and visual devices installed by owner, such as nanny cams or hidden cameras. The owner is advised to post notice disclosing the existence of security devices on the premises, if any. Well, I can tell you right now, a lot of people don't do that, and they need to, so make sure you're advising your clients appropriately. Adverse information. Owner has disclosed to listing broker all material latent defects and information concerning the premises known to owner, including all material information relating to connection to a public sewer system, septic tank, or other sanitation system, the existence of any tax judgment or type of lien, past or present infestation by or treated for wood destroying pests or organisms, and past or present repair of the premises for damage resulting from wood destroying pests or organisms. During the term of this agreement, owner agrees to continue disclosing to listing broker all additional information of the type required by the preceding sentence promptly after owner becomes aware of any such information by updating the seller property disclosure statement, residential lease owner's property disclosure statement, or other written notice. Please keep in mind that if you have already delivered, let's say you're under contract, if you have already delivered the seller disclosures and received it back from the seller signed, buyer signed, my apologies, and you have to update it, you have to resend it back to the buyer's agent, and they then get an additional 5 days to review it and agree. And they have another reason or way to cancel and get their deposit back. So just make sure that your client, if they have any updates, it's done immediately and it's immediately delivered to the opposing party. Disclosures. Owner shall provide listing broker with accurate information about the premises. Owner acknowledges that Arizona law requires owner to disclose material important facts about the premises, even if owner is not asked by the buyer or a real estate agent. Owner agrees to provide the following disclosures if applicable. Affidavit of disclosure. If the premises is located in an unincorporated area of the county and 5 or fewer parcels of property other than subdivided property are being transferred, the owner shall deliver a completed affidavit of disclosure in the form required by law to buyer within 5 days after purchase contract acceptance. Disclosure of lead-based paint and lead-based paint hazard sale or rental. If the premises structure was built before 1978, federal law requires that owner provide the buyer or tenant with a lead-based paint disclosure form. Domestic water well addendum, seller's property disclosure statement. If the premises is served by a domestic water well, the owner shall deliver a completed domestic water well addendum to buyer within 3 days of contract acceptance. Notice there's a lot of timelines in here. Study this. Write a cheat sheet. Foreign Investment in Real Property Act, Tax Act certificate. The Foreign Investment of a Real Property Tax Act, otherwise known as FIRPTA, is applicable if an owner is a non-resident alien individual, foreign corporation, foreign partnership, foreign trust, or foreign estate, otherwise a foreign person from another country. Owner agrees to complete, sign, and deliver to escrow company a certificate indicating whether owner is a foreign person, FIRPTA, requires that a foreign seller may have federal taxes, income taxes up to 15% of the purchase price withheld, unless an exception applies. Owner is responsible for obtaining independent legal and tax advice. HOA condominium planned community addendum. If the premises is located in a residential HOA condominium or planned unit development, owner shall complete, and return to listing broker page 1 of the HOA addendum. Insurance claim history, owner shall deliver to buyer a written 5-year insurance claims history regarding the premises, or a claims history for the length of time owner has owned the premises, if less than 5 years, from owner's insurance company or an insurance support organization or consumer reporting agency, or if unavailable from these sources, from owner within 5 days after purchase contract acceptance. If your client is maybe getting older or they're an investor and they don't maybe remember where they had it, if they had it, or maybe they're not able to provide insurance claims history or a seller disclosure because maybe they never lived there, then you can type that into your listing description and you can add it to the contract, just stating that the seller is unable to provide claims history or SPUDs. Also, fun fact about insurance claims history, if a deed was transferred from one person to another, you only need insurance claims history for the time period of the most current deed. For example, dad bought his daughter a house. Dad transferred the deed after 2 years to his daughter. Daughter goes to sell it 2 years later. You only have to provide insurance claims for the time the daughter owned the home because she is now the legal owner of the home. The dad is not. She still has to write everything that she knows about the property on the seller disclosures, but she only has to provide the claims history for the amount that she has owned the home or had it in her name. Residential lease agreement. If the premises is to be sold while subject to a lease, owner shall provide a copy of the lease to the listing broker. Residential lease owner's property disclosure statement, otherwise it's just the SPUDs for the rental home. Owner shall provide a copy of the lease to the listing broker. Oh, I'm sorry. Lost my thought. The SPUDs is designed to protect the owner by disclosing pertinent information regarding the premises. Seller's property disclosure statement, otherwise known as the SPUDs. That is designed to protect the owner by disclosing pertinent information regarding the premises. The owner shall complete and return the SPUDs to listing broker. Solar addendum, if the solar photovoltaic, whatever that is, panel system has been installed on the premises that is subject to a lease or unpaid loan, owner shall complete and return the solar addendum to listing broker. If the listing broker recommends a builder, contractor, escrow company, title company, pest control service, appraiser, lender, home inspection company, or a home warranty company, or any other person or entity to the owner for any purpose, such recommendations shall be independently investigated and evaluated by the owner, who hereby acknowledges that any decision to enter into any contractual agreement with any such person or entity recommended by listing broker will be based solely upon such independent investigation and evaluation. Owner understands that said contractual agreement may result in compensation or fee of listing broker. Owner agrees it will not allow mechanics liens to be recorded against the premises during the term of this agreement or at any time prior to close of escrow. Indemnification, owner hereby expressly releases, holds harmless, and indemnifies listing broker, all boards or association of realtors, MLS, and all other brokers from any and all liability and responsibility regarding damage or loss arising from any misrepresentation or breach of warranty by owner in this agreement. Any incorrect information supplied by owner and any facts concerning the premises not disclosed or withheld by owner, including without limitation any facts known to owner relating to adverse information or latent effects. Remedies. The owner and listing broker agreed to mediate any dispute or claim arising out of or relating to this agreement. All mediation costs shall be paid equally by the parties. In the event that mediation does not resolve all disputes or claims, the unresolved disputes or claims shall be submitted for binding arbitration. In this event, the parties shall agree upon an arbitrator and cooperate in the scheduling of an arbitration hearing. If the parties are unable to agree on an arbitrator, the dispute shall be submitted to the American Arbitration Association in accordance with the AAA arbitration rules for the real estate industry. This decision of the arbitrator shall be final and non-appealable. Judgment on the award rendered by the arbitrator may be entered in any court of competent jurisdiction. Notwithstanding the foregoing, either party may opt out of the binding arbitration within 30 days after the conclusion of the mediation conference by notice to the other. In such event, either party shall have the right to resort to court action. The parties agree that any and all disputes or claims will be brought to the party's individual capacity and not as a plaintiff or class member of any purported class, collective, representative, or other consolidated proceedings. The parties hereby waive their right to commence, become a party to, or remain a participant in any group, representative, class, collective, or hybrid class collection action in any proceeding, and the arbitrator shall preside over any form of a group, representative, or class collective proceeding. Attorney costs and fees. The prevailing party in any dispute or claim arising out of or relating to this agreement shall be awarded their reasonable attorney fees and costs. Costs shall include, without limitation, expert witness fees paid by two investigators, and arbitration costs. Additional terms and conditions. This could be a couple of different things. One common thing is that if you want to protect yourself from losing money, say out-of-pocket expenses, if maybe the seller decides later down the road they don't want to sell because it's been sitting on the market, if the contract hasn't expired, you could put in here, things like seller to reimburse listing broker X amount, and whatever the reason might be, you could put that here. You could also put some kind of disclaimer that the listing broker has the ability to change the sale price from X amount to X amount without additional written documentation from the seller, something like that. Basically, what that states is that if we're in a market where you're having to reduce the price multiple times because that's just what the market's doing, then you don't have to have them sign a listing contract addendum every single time you change the price. Just saves you from having to do a lot of paperwork. The assignment, neither listing broker nor owner may assign any rights or obligations pursuant to this agreement without the prior written consent of the other, and any attempted assignment without consent shall be void and of no effect. This agreement shall be governed by Arizona law. Jurisdiction is exclusively conferred to the state of Arizona. Unless otherwise provided, delivery of all notices and documentation required or permitted shall be in writing, addressed to owner and listing broker as indicated in section 11 and 12, and deemed delivered and received when either hand-delivered, sent by fax, sent by electronic mail, if email addresses are provided on this form, sent by recognized overnight courier service, or sent by U.S. mail, in which case the notice shall be deemed received when actually received or 5 days after the notice was mailed. Make sure you keep receipts. Copy yourself on any emails, that kind of stuff. All references to days shall be deemed to be calendar days unless otherwise provided. Copies and counterparts. This agreement may be executed by fax or other electronic means and in any number of counterparts. A fully executed fax or electronic copy of the agreement shall be treated as the original agreement. Entire agreement. This agreement and any addenda and attachment shall constitute the entire agreement between owner and listing broker and shall supersede any other written or oral agreements. Validity or enforceability of one or more provisions of this agreement shall not affect any other provisions of this agreement. The failure to initial any page of this agreement shall not affect the validity in terms of the agreement. Acceptance. The undersigned agree to the terms and conditions set forth herein and acknowledges receipt of the copy of this agreement. So if you're going to be sending them fax or well, yeah, if you're going to be sending them faxes, you should probably have their fax number in this section. You definitely need to have their email address and their phone number. You don't necessarily have to have their address, but if you can fill out all this information for the owner, please do so and make sure it's accurate. And last but not least, the listing broker. The agent is a member of whatever agency you're a member of or association. I'm a member of WeServe, so I put WeServe. And subscribes as a realtor for Code of Ethics. Your name, your firm name, your phone number, your email. And that is it. So once again, tonight we continued to work with the seller and we reviewed the residential listing contract, exclusive right to sell/rent. Does anyone have any questions regarding the document we just reviewed? Perfect. Well, have a great evening and I will see you next week.